You are likely watching this video because you have received notice that you are the subject of an indicated report, and you are looking for more information on what to do next. Through this video, in the attachments, you will receive information on how to appeal the indication. The agency that investigates reports of child maltreatment is called Child Protective Services, or CPS, in upstate counties, and is called the Administration of Children's Services, or ACS, in downstate. I will use CPS throughout this video, but I am referring to ACS as well. Reports of child maltreatment are made to the statewide Central Register, or SCR, which is a call center operated in Albany. Reports made to the hotline are either accepted or rejected. About 1/3 of reports are accepted. They are then sent to the local CPS for investigation. There are two outcomes. The report may either be indicated or unfounded. About 1/3 of reports are indicated. When a report is indicated, it is maintained in a database with the SCR for 18 years after the youngest child's birthday. Please note, though, that law will change effective January 1st, 2022. Thereafter, reports will be maintained only for 8 years, and any reports older than 8 years on January 1st, 2022 will be sealed. An indicated report can affect a person's ability to become a foster parent or adopt a child, or keep them from being able to work in a job where they may be in contact with children. Often, people don't even know that they have an indicated report against them until they apply for a job working with children, and by then, the time to appeal has expired. This video outlines the process by which a person can find out if there are indicated reports against them in the SCR database, and how to attempt to appeal the report. All templates will be available in the description of the video, along with a PowerPoint version of this video. Near the end of the video, we will show ways to edit a template PDF online. In order to find out if you have a report against you in the SCR, you must first write to the SCR and ask if there are any records about you or your children. In the same letter, you should request that the SCR seal or expunge those records. And just in case the request is denied, you should request a hearing. An example of a letter you can send is: put in your name, address, and the date. If you have your case ID number, write that in, and then for the actual letter, you should write your name and the date of birth. Sign at the end, and then send this letter to the SCR. After writing to the SCR, there is a high possibility that you will receive a letter from the Office of Child and Family Services, OCFS, that states that your request to expunge or clear your record is too late. You will receive a letter that looks like this. Generally, if a person wants to appeal their record, they must begin the process within 90 days of receiving a letter that states that there are records against them. In order to counter this, you can write a letter to the OCFS and state that you have received the letter too late or that you have never received it at all. An example of a letter you can send is, and in this template you should write in your name, address, and the date and your case ID number. In the letter, write your name, the date on which you wrote a letter requesting your records, and then the date on which you received a response from the SCR regarding your indicated report. At the end, sign and send this to the SCR. Along with this letter, you should attach a memo from the OCFS, which states that late requests should not be denied because the ACS must provide evidence that they sent the letter within 90 days, which can be difficult to prove, as they generally do not send these letters through registered or certified mail. The note looks like this. This will push OCFS to consider your request. Once you have received a letter from the OCFS with your records, you need to read through and determine the status of your records. Reports can be either marked unfounded, indicated, or substantiated. Unfounded means that CPS has not found sufficient evidence to prove that the report was true. This report will still be filed at the SCR but is sealed and unavailable to employers but can be accessed by CPS caseworkers. indicated or substantiated means that CPS has found some credible evidence to prove that a report was true. These reports are usually available to employers, foster care and adoption agencies, the police, and courts. Another change to the law that will go into effect on January 1st, 2022 is that the burden of proof for a CPS caseworker to indicate a report will rise from some credible evidence to preponderance of the evidence. If the status of your report is unfounded, that means there are no indicated reports against you. Congrats! If the status of your report is indicated or substantiated, there are records of child maltreatment that will be kept for the next 8 years, affecting various aspects of your life. When you initially submitted a request for your records to be cleared, the OCFS had begun an administrative review to examine the reports against you. The OCFS, however, will only have access to the CPS's point of view, so providing additional information such as letters from others to prove that the CPS was wrong will be helpful. At the end of the administrative review, if the OCFS finds that reports should be unfounded, the OCFS will seal them. However, if the OCFS denies your request to clear those records, you will be scheduled for a hearing. You will receive a notice to appear before an administrative law judge that looks like this. A representative from CPS will also be there, and so may a lawyer or paralegal. At this appearance, you'll provide any documents that you want the court to consider, as well as the CPS representative. The CPS representative will provide you with a redacted copy of their case records. You will then choose a time and date for the hearing. If you cannot attend the first appearance, make sure to request to reschedule. An example of a letter you can send to reschedule your hearing is: for this template, write in your name, address, and the date. Then write in your case ID number and the name of the judge. For the letter, write in your name, as well as the time and date that your hearing was originally scheduled for. Also write in why you cannot attend that original scheduled hearing, as well as the days you are unavailable. Before the hearing, you should carefully read all the case notes in the packet you have received from the CPS representative. Make note of anything you want to ask the caseworker, such as anything that you have been coded as saying that might be inaccurate, or any notes that contradict another note, as well as other things like that. On the day of the hearing, the CPS representative will start their case first. They have the burden of proving that the allegations made against you of child maltreatment by a preponderance of the evidence. This means that it's more likely than not that the allegations are true. Another way to think about it is that it's 51% likely that the allegations are true. The CPS representative may submit their case records and then rest, or they may call witnesses such as the caseworker who investigated the report, the caseworker's supervisor, or a different caseworker if the original caseworker is no longer working in that capacity. When the CPS representative has finished with their witness, you will have an opportunity to cross-examine their witness. That means you can ask them questions. It is important to be respectful to everyone, even if you're feeling upset. You will then have an opportunity to present your case. You will likely want to testify as to your version of what happened or didn't happen. You may want to call witnesses who can testify to those events. You may also want to call character witnesses who can testify to your good character. In some appeals, you can admit that the allegations are true, but that you have rehabilitated yourself and that the report is no longer relevant. For example, you may have had a substance use disorder which led to child maltreatment, but since then you have received treatment and maintained abstinence from substances. You can provide documents showing that you have rehabilitated yourself, such as a certificate of completing a substance use treatment program, a letter from a counselor, or a certificate from a parenting program. About 4 to 8 weeks after the hearing, you will receive a written decision in the mail from the administrative law judge notifying you whether or not your records are sealed and expunged. If you win, your records will be sealed. If you lose, you can appeal by filing a lawsuit under Article 78 of the CLPR against OCFS and CPS. You will need a lawyer and must file the suit within 4 months of the fair hearing decision. In this video, various letter templates were shown. They are all available in the description and can be easily edited online. You should find the files you need and download them. Once you have downloaded the PDF, go on to www.pdfescape.com and open the files on the website. On this website, you can enter your information and save the edited PDF. From there, you can print your letters at home or at a local library or store. Do remember to change any information that may not be applicable to your situation. Best of luck!